Hi guys, Jonathan Daly, managing attorney for Daily Law here, and here is a quick important point when it comes to a security deposit dispute. If the landlord kept a portion of your security deposit and they send you a notice imposing a claim on it and it requires you 15 days to object to it, make that objection and make sure to make a point that a lot of times the landlord was right to keep a portion of the deposit, but there are certain costs such as repainting if you didn't damage it and new carpets, etc., that the landlord is not allowed to charge against your security deposit. And if they do so, point that out and remind them that the prevailing party under Florida is entitled to their attorney's fees and costs if court action is required to have them return that portion, the security deposit. And here's the kicker. It depends on the judge in the case, but there is case law that is in your favor as a tenant if you can just show that they kept $1 more than they should have. And there's case law that says you're the prevailing party when it comes to the attorney's fees provision. And that's the kicker. That means even if the landlord was right to keep most of what they kept, if you can show that they kept just a little bit more than they were supposed to, there's an argument that you're the prevailing party and you should be entitled to your attorney's fees and costs, and not might be enough to get that portion or maybe the whole deposit back from your land. So this was helpful.